Hey everybody, welcome to another Summer Smasher Oceanside chat. This week we are diving into patents with our very own Kevin Debre. He is a gold star mentor and support of the Viterbi Startup Garage. He has been doing bi-monthly legal clinics that are typically closed just to garage teams. So it's a really great opportunity for you guys to see one of these because it happens to coincide with Summer Smasher. So without further ado, let me pass it over to Kevin Debre. One of the things I wanted to mention that is part of his bio is that he's been selected for Southern California's super lawyers. What's a super lawyer, Kevin?
I don't know, but I'll take the accolade just the same.
Oh, you are super. You also represent, businesses of all different sizes and, different markets and all sorts of different industries, from startups to, kind of middle stage. And I really appreciate the fact that you have spent so much time with our teams who are kind of early stage. But I know that that Stubbs Alderton does some stuff for startups on their own in some sort of service providing way. Can you talk a little bit about that?
Sure. Thanks, Arciela. So yeah, we in the past have been sponsors of business plan competitions, new venture seed competition at the Marshall School of Business, the Massey Entrepreneurship Prize competition through the Viterbi School of Engineering. And I myself have done a number of presentations at the Startup Garage and in classes at the Marshall School. And as well as, I guess I should say that I hold monthly office hours at the USC Incubator at the Marshall School.
Very cool. Well, go ahead and take it away. I'm going to pass the mic over to you.
Okay, thank you, Arciela. Well, everyone, it's great to be here again for another legal clinic. I should stop calling them quarterly because we are doing them bi-monthly, as RC had said. So in the past, legal clinics have included startup legal issues and excuse me. And let me continue on. And startup legal issues and contract basics. And today we're going to be talking about sort of a deeper dive into patents and the pros and cons of patents as IP protection. And then in 2 months, we're going to be doing another legal clinic on seed financing and term sheets. So hopefully you'll be able to join us for that one as well. And these will continue through the year on a bi-monthly basis. So by way of background, I'm a partner with Stubbs, Alderton, and Markiles, and I like to say that we're a big firm, a boutique firm with big firm capabilities. We cover a lot of areas of legal practice that are relevant to entrepreneurs and fast growth, emerging growth technology companies, as well as middle market companies and larger companies as well, because startups sometimes grow up and become larger companies. So that includes venture capital, financings, corporate and business transactions. I run our intellectual property and technology transactions practice. We have specialists in privacy and data security, trademarks, digital media, and important to fast growth companies is mergers and acquisitions. That's the most likely exit for a emerging growth company. We also have a public securities practice, and in the event that there is a dispute, we have a business litigation team. And as I indicated, we have a long history working with and supporting USC entrepreneurs. Here's sort of a sampling of some of the companies that we represent and have represented in the past that have been founded at USC. And a little bit about me. I'm a combination, a hybrid of a business lawyer and a intellectual property lawyer. I was an engineer before going to law school. I'm a registered patent lawyer, and my practice really focuses on the commercialization of intellectual property. So if you look at the Venn diagram in the slide, I kind of see intellectual property as having three principal areas. There's protection, that's securing intellectual property rights; enforcement, that's going to court or arbitration and enforcing or defending intellectual property rights; and then sort of the sweet spot in the middle is commercialization, which I view as sort of building value within a company through the leveraging and use of intellectual property that has been protected by the company and sometimes needs to be enforced. So that's really the area, the world that I work in, is commercialization, negotiating agreements and deals involving customers, suppliers, strategic partners involved in the development of intellectual property or commercialization of technology. So with respect to today's presentation on patents, here's the agenda that I've outlined. We're going to talk about, what do patents protect? What qualifies for patent protection? What rights do patents provide? How are patent rights obtained? Who owns the rights in a patent? How are patent rights enforced? And then how to build an IP portfolio on a startup budget. Starting with the first topic, what do patents protect? They protect inventions. And there are different kinds of patents for different kinds of inventions. There are utility patents, design patents, which protect non-functional designs. So it could, if you imagine a light fixture in the shape of the Venus de Milo, that could be protected by a design patent, the ornamental, non-functional aspect of that design, not the light fixture itself. And plant patents protect asexual plants in seeds. Today, we're going to focus on utility patents. That's the area that is most common and is usually of most interest to technology companies. Utility patents protect machines or articles of manufacture. These are products, compositions of matter, which are chemicals, processes, and importantly, improvements of existing items that I just listed. So it could be an improvement of something that existed before in those categories. Now, within the realm of processes, that's where we get software patents, because software essentially is a process that accomplishes or does something through the use of a computer or information technology system. So that's the realm of where software is typically patented when a patent application for software is filed. Patents protect inventions that are created by human beings. They do not protect things that are naturally occurring, abstract ideas, laws of nature, natural phenomenon. So it's important this is the first step in understanding what is patentable, whether you have a patentable invention, and that is, does your invention fall within the categories of what's called statutory subject matter that is eligible for patent protection? What inventions can be patented? So patentable inventions really must meet three requirements. They have to be novel, they have to be useful, obvious. So what do those three requirements mean? Novelty essentially means it hasn't been invented before. In essence, what the law requires is that the invention that is sought to be patented was not described in a printed publication, is not in public use, or is not not in public use, and is not on sale or available to the public. And there's an exception. Well, what if the inventor who is seeking patent protection has published his or her invention in a publication, or has used it in public, or put it on sale, or marketed it? Then what? In the United States, there's an exception, and that is if those activities were conducted by the inventor, then the inventor has 1 year to file a patent application, and it will still be eligible for patentability. That, however, if any of those activities were done by somebody else, and importantly, if the invention was described in a patent or in a published patent application by another inventor who filed that application first, then the first inventor is entitled to the patent that results from that patent application. So you could be in a situation where you have two inventors, and I've seen this, who've invented almost the same thing, different parts of the country, independently invented, and have filed patent applications close in time to each other. Who gets the patent? The one who filed first. It used to be under the law prior to 1996 that it was the inventor who was first to invent was entitled to the patent, but that has all changed, and now it is the first to file. And I'm sorry, that date is 2013. That was the American Invents Act of 2013. Was when the law changed. What is the utility requirement? This is a very easy requirement for inventions to meet. It's a little challenging for chemical compounds that don't have a readily identifiable purpose. But for most inventions, particularly mechanical inventions, electrical inventions, this requirement will be met, and that is that the invention must be useful and it must operate, it must work. And the invention cannot contradict well-established scientific principles. Well, what does that mean? Do you have to actually create a prototype of the invention in order for you to meet the utility requirement? Absolutely not. You just need to be able to describe the invention in sufficient detail such that the inventor is reasonably confident that it will work as described. So you don't necessarily have to have created a demo or a prototype of the invention, although that helps. What the requirement that it cannot contradict well-established scientific principles means is that you cannot, let's say, invent an anti-gravity machine or a perpetual motion machine without actually proving that it doesn't violate the laws of physics. So that's where we sort of get into the realm of, also subject matter that is not abstract ideas. It really has to be an invention of something, and it has to work and be useful. Non-obviousness, the non-obviousness requirement. This is a tough one, and this is where a lot of applications for software patents stumble, and that is that the invention cannot be obvious to a person of ordinary skill in the art at the time that the invention was conceived of or made. What that means is you don't have to be an expert, but somebody who is reasonably knowledgeable in this area of technology wouldn't have thought it obvious to invent the invention that is being applied for. And this analysis could include reference to more than one pre-existing invention or technology. So let's take, for example, an invention that involves an office chair with a set of pedals attached to it so that the person using it, the worker or the executive who is sitting at their desk, is pedaling away and burning calories while they are working at their desk. Well, that's probably going to fail for non-obviousness because the chair itself is well known and established, And the use of pedals for exercise on a bicycle or an exercise bike or something like that is well established. And it would be obvious to somebody of ordinary skill in the art creating mechanical inventions like this to combine the two to create the office chair exercycle. So that's an example of where one or multiple prior art references or pre-existing inventions can be used to establish obviousness and therefore render the applied for invention ineligible for patentability or for a patent. Software patents or patent applications stumble in this area, like I said, or it's challenging to obtain a patent for software because of non-obviousness, because many times software applications will describe a function of software that takes place in the physical brick and mortar world and has moved that function or process online into, let's say, a SaaS environment or online environment. And the patent office is going to look at that and say, well, you know, somebody reasonably or of ordinary skill in the art of software development design would think it obvious to take that process in the physical brick and mortar world and create a software program to do it. So now let's talk about what rights do patents provide. And by the way, I should mention that I'm going to sort of speed through my presentation because I've got a lot of ground to cover, and I'm going to reserve some time at the end to take questions. So hopefully you'll be thinking about questions along the way so that we can have a good Q&A session then. So what rights do patents provide? Patents provide essentially a limited monopoly. And the bargain that the government makes with the patent owner is that in exchange for making the patent or the invention available to the world through publishing the patent, in exchange for that publication, the government grants the patent owner a limited monopoly. Now, what is that limited monopoly? It is to exclude others from making, using, selling, offering for sale, and importing the invention claimed in the patent. And that is importantly within the US or the country where the patent is issued. So it's important to recognize that a patent doesn't necessarily give the owner the right to use or make their invention. It just provides them the right to exclude others from doing so. Well, what's the difference? The difference is probably best illustrated through an example. Let's say you have a patent for a, let's say, a chip that goes into a mobile phone, and that chip provides certain functionality. And there's somebody else that has the patent for operating multiple mobile phones within a cellular network. So the owner of the chip patent would not be able to use their mobile phone within a cellular network without a license or the permission from the owner of the patent of the cellular network system patent to use it. So in that way, that's kind of an illustration of a dominant patent. The system patent dominates the chip patent and prevents the chip patent owner from being able to practice their invention within that system environment. And I will get into in a minute when I talk about the guts of a patent, what the term claimed means. But it's important to know that what the right to exclude covers is just what's claimed within the patent. So how are patent rights obtained? In contrast to, for example, trade secrets, famous trade secret is the Coca-Cola formula. How do you keep it protected? You keep it secret. Here, a trade secret, if it meets the 3 requirements of patentability and is patentable subject matter, that we just talked about earlier, then you can obtain a patent through filing a patent application. You can't just sit on it. There are two types of patent applications: provisional patent applications and non-provisional patent applications. A provisional patent application is essentially just a placeholder. Remember, I talked about earlier that the first inventor to file a patent application is entitled to the patent that ultimately issues. What the provisional patent application does is it provides the applicant a filing date, establishing their priority for that first to file race. So this enables and it's good for 12 months. So this enables the inventor the ability to establish their priority by filing a provisional patent application as hopefully being the first to file, and then deciding within that 12-month period whether or not they want to proceed with examination of the application. And I'll talk about what examination means in a minute. But the provisional patent application doesn't get reviewed by the patent office. It's just kind of sits there waiting for the patent applicant to do something with it, or not. If the applicant doesn't do anything, it expires and goes away, never gets published, never becomes part of the public domain. The benefits of provisional patent application is they're relatively inexpensive. The patent office charges reduced fees, filing fees, for filing a provisional patent application, and you don't need to have a lot of the elements such as claims, drawings, and declarations that are required of a non-provisional or normal patent application. So it enables inventors to get something on file relatively quickly, and gives them sort of breathing room to decide whether they want to proceed further with it. So a non-provisional patent application is the full-blown patent application that we all know and love. And this has all the elements that a issued patent, you would see that an issued patent has. It has an abstract, that's a summary of what the invention is, a detailed description of the invention, which would include the background of the invention, why it provides advantages over the existing state-of-the-art, or what's called the prior art. It has drawings that correspond to the detailed description of the invention. It has claims. The claims are the property line, the picket fence, if you will, defining the property rights of the patent that with respect to the invention that is described in the detailed description of the invention. Let me say that again. The claims are the property rights, or define the property rights of the patent with respect to the invention that is described in that patent. And then you have an inventor's declaration, basically saying that the inventor is set forth to the best of his or her knowledge about the invention, implementing the invention. Now, a couple of things to consider, and in particular entrepreneurs, when they think about an invention or their invention, they typically think of the way that they thought of it. Now, I'm just going to check and see if I'm frozen. RC, am I still being received?
Oh, you're good.
Okay, good. Thank you. All right. So, but as a patent applicant, you don't necessarily need to just limit yourself to the way that you are going to implement your invention. In fact, you'd be wise to think of alternative, what are called embodiments of the invention. Because number one, by the time you get into production, you may decide that you're going to implement your invention in a different way to save on costs or use different materials. But most importantly, when a patent application is published, and that occurs what you have disclosed to the US Patent and Trademark Office. And that includes your competitors or potential competitors. And so what you want to be thinking about, and what a good patent attorney will be thinking about as they put together a patent application, is how is a potential competitor going to try to design around what you are claiming in your patent application or your issued patent. So you want to think like a competitor after you've gone through the exercise of describing and putting into words how you intend to implement your invention. So after you file the patent application, I'm going to run through this process of patent prosecution. It usually takes a couple years. I'm going to run through it very quickly. You submit the application to the US Patent and Trademark Office. It then gets examined by what's called a patent examiner. And these patent examiners are specialists in their areas of technology, and they're within different what are called art units within the US Patent and Trademark Office. And they will conduct what's called a prior art search. They're going to look to see what else is out there. If there are other inventions that have been patented or described in pending patent applications. And again, these are applications that have been published 18 months after filing, or maybe even printed publications that are outside of patents and pending patent applications. And they will come back with the results of their search. Now, I just want to mention, as we're talking about non-provisional patent applications, this could be a new application that's filed, or it could be the matriculation of a provisional patent application or conversion of a provisional patent application before the 12-month expiration date into a non-provisional patent application. So when the patent examiner completes his or her prior art search, they will typically respond to the application by sending the applicant or their attorney what's called an office action, saying, we found this prior art and we think that claims, and that's what they're really looking at, are the claims, the numbered paragraphs at the end of the patent application, that certain claims overlap what is already in the prior art and therefore not eligible for patenting. So the patent office examiner may suggest an amendment or may just say, we're rejecting these claims, we're allowing other claims, go forth. You are always generally always going to have this go through this process of back and forth with the patent examiner, because you don't know how broad, and this is the key here, the value of a patent is your ability to enforce it, and your ability to enforce it depends often on how broad your claims are, because you want to be able to sweep in as much of a potential infringing, and we'll get into what an infringement is, devices or products or processes within the scope of your claims, your patent claims. So you're going to overreach. You're going to apply for claims that are probably broader than you are entitled to receive. But the only way you're going to know how broad you can get patent claims is by getting pushback from the patent office. It's kind of like buying a house. You don't know how low a price you can get for that house unless you lowball the seller and they push back and say, no, we're not going to sell it to you for $5 million, but we'll take $5.5 million. So, which is typical in today's real estate market. So that's where these amendments and office actions come in. This is a negotiation with the patent office on the breadth of your claims. So you also, within 12 months of filing your application, whether it's provisional or non-provisional, need to decide whether you're going to file an application under the Patent Cooperation Treaty. This allows you to streamline your foreign patent application filings. And what's important here is you just need to decide whether you're going to go into foreign territories or not. And if so, then you would file what's called a PCT application at this 12-month mark. You don't need to decide which countries you want to file in until sometime thereafter. And that's going to
Kevin,
be
does that include Canada?
Yes, it does.
Thank you.
Mm-hmm. And so you will, this decision will be based upon cost, because this is where the expense of patent applications really increases by having multiple foreign patent applications on file. So that's something, but that's a decision that you can defer until 30 plus months after the initial filing date. After you go through this negotiation process with the patent office, hopefully at the end of it, you will receive what's called a notice of allowance, which means your patent is about to issue. And congratulations, you get to pay an issue fee to the US Patent and Trademark Office. And after the patent issues, periodically during the life of the patent, you will need to pay what are called maintenance fees. These are fees that you will need to pay in order to keep the patent alive. So this is an illustration of, or an example of a patent. And I chose this one because it's completely silly. It's surprising that somebody was even able to get a patent on this, but this is for a TV control device. Those of you who are my age or older will know, or will remember, that televisions used to look like this. And instead of having a remote control, this invention was a telescoping rod that fits into the dial of the channel changer of the TV, and allows the viewer to change channels on the television. And what I wanted to show you, though, is this is the description of the invention. And I'm not going to leave this up too long, but if you take a moment to read some of it, you will see that this is a different kind of language. Typical entrepreneurs don't speak this way. This is patent attorney speak. And so I say this because this is really a specialized area of law and practice. And even though you do not need to be a patent attorney to file a patent application for your own invention with the US Patent and Trademark Office, I think you'd be smart to hire a specialized area. These people, patent attorneys, speak the language that is very unfamiliar to entrepreneurs. But so you go through the patent, and it talks about the description corresponding to figures and diagrams in the patent application. And then we come to the very end, which says I claim. These are the claims that I was talking about earlier, which is a TV control device for rotating a dial of a TV set. This is the property line that the inventor is drawing, the applicant is drawing for his patent. So, and the other thing to keep in mind is everything in here in this claim must have support somewhere, meaning there must be a reference for it somewhere in the detailed description of the invention. And this is where the rubber really hits the road on patents and enforcement of patents, because a lot of patent litigation turns on the interpretation of words, individual words, and what those words mean. And the interpretation of those words is often found in the detailed description of the invention, and then experts will opine on what the definitions of those words are. There may be testimony about what the inventor meant at the time that he was submitting the patent application. So these words are very critical to the patent owner's ability to enforce their patent. So what does it cost to obtain a patent? Well, these days, it can cost between $15,000 and $50,000 per invention. Now, I think 15 is probably on the low end. We're probably talking 10 to 15 just to prepare and file a patent application. And then it goes up from there when you get into the prosecution of the application, the back and forth negotiation with the patent office. Well, it can get up to $50,000. That's on the high end. That's pretty extreme. I think that's probably including foreign applications. But you start getting into $4,000 plus per country, and those costs can add up very quickly. And it's important to keep in mind that this is just for one patent application. And we're going to be talking about how to build an IP portfolio. Portfolio means multiple patent applications. Well, why would you want to have multiple patent applications or multiple patents? Well, a couple reasons. Number one is, as I always like to say, innovators will continue to innovate. So the invention that you have today is not your last invention. And so that requires you to kind of think about how you're going to budget for the future. And then the second reason is that patent enforcement often involves 1, 2, 3, and the accused infringer may say, no, I don't. Patent 1, 2, 3 is invalid. And by the way, you infringe my patent. And so the first plaintiff, the first patent owner will say, well, okay, in addition to patent 1, 2, 3, you infringe patents 4, 5, and 6, and 7. So that's why a patent portfolio consisting of multiple patents is what an IP strategy involves, so that there is the opportunity to assert multiple enforcement action or multiple claims of infringement in an enforcement action. Who owns the rights in a patent? This is something that is often confused by entrepreneurs. And in this case, and the rules for different types of intellectual property vary. Here, an inventor owns his or her invention unless there's a written assignment agreement. And what happens if the inventor is an employee of a company? Doesn't the employer or doesn't the company own the invention? Well, only if the company has what's called it's called many things, but it's an IP assignment agreement or an employee proprietary information and assignment agreement, which provides an assignment. It provides that the inventor employee agrees to come out of those inventions to the employed within the scope of the employee's work, employment with the company. If there isn't such an assignment, then the employer may own the invention, and this is under common law, if the employee was hired specifically to invent. This is kind of a rare exception. Maybe it's for certain types of engineers. So there may be a basis if the company doesn't have such an agreement in place to claim that they own the invention, even if there isn't, if that the employee created. And in absent this hired to invent exception, then at best, the employer has what's called a shop right. That means a right to exercise or use the invention in connection with the business, but the inventor employee would retain ownership of the invention. And that means the inventor employee can leave the company and go start his or her own company, or license the invention to a competitor. So not a good outcome for the employer. That's why it's important for companies to have these IP assignment agreements in place for all employees. What about co-ownership? I know that sometimes I'll be working with a client that wants to enter into a joint development agreement, and under those circumstances, sometimes both parties will collaborate and create an invention together, each contributing to the invention. And my client might say, well, let's agree to co-ownership. That's okay, or that seems fair. Well, maybe under certain circumstances, but the problem is that a co-owner has an undivided interest in the entire patent that results from the invention. And that means that they have all the rights in the patent without having a requirement to get consent from the other co-owner or accounting to the other co-owner for how they use the patent, which means one co-owner can license or transfer the patent or their rights in the patent to a competitor. So, it's really important in situations where there is co-inventorship to really think about what ownership makes sense given the company's objectives. And maybe and this is a common solution, it's a way of defining, well, co-invented inventions that are within this category are owned by company A, and co-invented inventions in a separate category of technology or application are owned by company B. Our patent rights enforced. They're enforced generally through taking legal action. There are different kinds of, and this is called patent infringement actions. There are different kinds of infringement theories. The one that I'm going to focus on is what's called literal infringement. And this is where the device or process that's accused of infringing the patent contains every element that is within a claim of the patent that is being asserted. What does that mean? Well, you'll remember those numbered paragraphs at the end of the patent that I showed you. That language in the claim contains elements, and you have to match up each of those elements to the accused device or process to see if it's contained in that device or process. If it does, bingo, you have infringement, and you only have to do that for one claim in order to have patent infringement. A device or process accused of infringement doesn't have to infringe all the claims, but the more the merrier, because what the defendant is going to do invariably is they're going to say, well, that claim is invalid, or there isn't the overlap that the patent owner says there is, or for some reason, the patent is unenforceable. So you want to be able to have a plan B, C, and D, which means typically in patent enforcement actions, you're going to have multiple claims being asserted that are infringed. Something to keep in mind, this is maybe a little obscure for this audience, but I'm going to bring it up anyway. Just because a accused device or process doesn't contain an element of a claim doesn't mean that it doesn't infringe. There's something called the doctrine of equivalence, and that means that the accused device or process performs substantially the same function in substantially the same way to achieve substantially the same result as the claimed invention. So is there an equivalence that could be asserted as a basis for infringement? I'll just leave it at that, but I just want to highlight here that analysis of whether there's an infringement is a very complex exercise and really should be done by somebody who is an expert in this field. I've had situations where engineers, believe it or not, will say in emails, I've looked at the patent and I don't, and we possibly infringe this patent. Don't say that in an email, and don't have your engineers perform infringement analysis. This is a legal analysis, not a technical analysis. So how much does it cost to enforce a patent? It's expensive, and the costs go up depending on how much is at stake, meaning how much damages are sought to recover. So in this study, this survey that I'm referencing, it's somewhere between 1.5 to $4 million in legal fees and court costs. And this includes expert witnesses who are called upon to provide testimony. But importantly, a study done by Mark Lemley in 2010 indicated that most cases settle. But those that go to trial, the patent owners win 32% of the time. Now, it's also important to note that only 15% go to judgment. That's because so many times there are reasons that it won't go all the way to trial. Trial is very expensive, and sometimes their cases are adjudicated before they go all the way to trial. But 75% of the time they settle because it is so darn expensive. And you need to kind of sort of go down the path of litigation so far to kind of size up your adversary, see how good their defenses are or their legal claims are to determine whether it makes sense to settle.
But Kevin, this is David Gerber. Can you go back just, so that seems to indicate that only 32.5% of patent holders in all of these potential outcomes of enforcement win, which means that 70%, even if you are infringing, win, unless I'm misreading this.
70%
of the infringers tend to win.
No. So patent owners win 32% of the time, but so this means, so there could be a no win. This could be a settlement, right? This could be a case that is not a win, but a where the case is dismissed, or the case is, let's say, yeah, I guess there are, so this goes to judge, so 15% go to judgment, and of that 15%, 32%, patent owners win 32% of the time. I guess you're right, that there is either a defendant victory or a reason why the patent owner doesn't win.
Thank you.
Yeah, good observation. Okay, so how to build an IP portfolio on a startup budget. And RC, I'm just doing a time check. We're at 121.
Mm-hmm.
I probably have about 15 minutes. Can we go a little bit over, do you think?
Of course, I would love for you to go over. You can go as long as you want, Kevin. Thank
Okay.
you so much for going over.
But I'll try to speed through this.
Awesome.
Okay. So, you know, I've kind of broken this down according to steps that a company can take in implementing an IP strategy based on the stage of the company's development and size and scale, where they are in the marketplace. So, and I've broken it down from there's development stage, validation stage, scale stage, and mature. And this is really kind of based on this famous curve that I'm sure you've all seen. And this is, you know, where startups will typically have to cross the chasm of the valley of death of funding. And this is where they get their initial capital and are building a prototype. And really, in my view, don't have a lot of capital or funds available to spend on patent applications. And then as successive rounds of financing take place, there's more room for that ability in the budget to protect their IP. And that corresponds to the various stages in their development and growth. So I'll show you what I mean by that. So really right-sizing the IP activities or IP protection activities to the stage of the company's development. So in the very beginning, this development stage, this is where a company is validating their technology, coming up with a business model, raising some initial capital, and the watchword here is being IP aware, just not losing what you have, preserving rights. So having the appropriate agreements with employees and contractors and keeping track of inventions by having what are called invention disclosure reports so that you can know what inventions have been made and decide in the future whether they make sense to file patent applications for. Creating an inventory of trade secrets. Oftentimes, companies will say, yes, we have trade secrets, and they're all right here in our employees' heads. Well, that's great, but if that employee leaves, or if there's a theft of trade secrets, you need to be able to know what trade secrets you had in the first place. And you'll be surprised how few companies have even taken the time and effort to develop this inventory. And then testing trademarks and brands, seeing, running clearance searches, doing some market research and customer discovery. This is all part of matching a company's early stage development activities to their IP aware practices. So the next stage is the validation stage. And this is where a company is testing a prototype, getting customer feedback and maybe making tweaks to its technology. They've done beyond maybe a friends and family round, maybe they've done a seed round. And this is now a time where the company can develop processes for evaluating the inventions and maybe filing some provisional patent applications on those that are sort of core technology or key to the company's growth and perhaps future success. And then sort of mapping their IP protection strategy or IP protection activities to their business plan. They're developing maybe an R&D plan and sort of mapping their IP protection activities to that R&D plan. And then again, more refinement of doing their trademark clearance searches and maybe filing on some trademark registration applications. Or sort of, this is where a company is beginning to systematize their IP protection activities through processes that align their IP to their business objectives. And this is a place that is good to consider, developing a screen for when to file a patent application and when not to, or when it makes sense to maintain it as a trade secret. So here are some reasons that I have identified for that would make sense for seeking patent protection. One of the most obvious ones would be this last one here, where if you're maintaining it as a trade secret, but as soon as you put it on the market and make it commercially available, the trade secret is going to be revealed to somebody who would buy or subscribe to your product or service and enable them to knock it off. That's where a patent really would provide an advantage over trade secret protection. But there are many other reasons that would make sense to consider patent protection for the inventions or some of the inventions that have been reduced to writing in an invention disclosure report that I described earlier. And then there are reasons not to seek patent protection. And one of them is infringement would be difficult to detect. And what I mean by that is, let's say you have a patent on a process for, let's say, taking payments from multiple users. Let's say taking a bill and splitting it among multiple participants so you can share the cost, users can share the cost of an expense. Something that is fairly common today. in an application. But what if that process that is identified and claimed in the patent specifically takes place on a back-end server or system that is not visible to the public and not visible to the patent owner? The patent owner may not know for sure that what appears to be an infringement of their patent actually does infringe by conducting the payment splitting process the same way as they've claimed in their patent. And that raises a quandary, a dilemma for the patent owner. Do I sue and then get into discovery and take depositions and ask for documents and look at the back-end server to see if the infringement takes place, and then maybe a couple $100,000 later determine that there is an infringement? Or do I let it go? So whether or not infringement would be difficult to detect is a reason or a factor to consider in whether or not to seek patent protection. The next business phase is scaling up. This is where the technology has been validated, and now the company is offering or coming up with additional product offerings. They're expanding into new markets and foreign territories, perhaps partnering with other businesses and companies for joint development and manufacturing and distribution, and there's competition. So there's a need to move quickly in order to stay ahead of the competition. So there are a few things here that the company can do to start building upon their previous efforts and creating this robust IP portfolio. And that is integrating IP awareness into the company's DNA. Well, what does that mean? That means really getting evangelizing intellectual property, getting people to understand, employees and management, executives, everybody within the organization to understand the importance of intellectual property and the importance of safeguarding it. Perhaps creating programs to reward employees for innovation or even just to experiment, giving employees time off to experiment, supporting employees who come up with innovations that want to perhaps spin off different business units. So there are lots of things that companies in this stage or business phase have implemented, looking at foreign IP protection, and at the same time now taking stock of what patent applications and issued patents have the company has, and evaluating the relevance from time to time. Perhaps some of them are no longer applicable to the company's business objectives, and it's a time to sort of cull the herd, to eliminate maintenance fees and what are called annuities in foreign jurisdictions, to reduce the cost of maintaining the patent portfolio and scaling it to just what is relevant to the company's business purpose. And then there's the mature phase, and this is where I suggest is an opportunity for a company to dominate. And this is where a company is building on the strengths of the IP portfolio that it has developed. And it is using intellectual property for business intelligence. Well, what does that mean? That means that it is doing periodic searches of the landscape to see what competitors are doing, or maybe identifying areas where there isn't patent activity, so that this could help direct the research and development that the company is going to undertake in order to sort of create a picket fence around, or what's called ring fencing, certain areas of technology that it wants to secure and not let its competitors get into. Maybe making strategic acquisitions of other companies or technologies in a sort of make or buy analysis. How much is it going to cost to make this ourselves, or just buy it from somebody else? And again, managing IP maintenance costs. This is where a company at this stage has hundreds, perhaps even thousands of patent applications and patents, and that could be hugely expensive, and it requires constant maintenance and assessment of the relevance of those applications and patents to determine whether those are costs that make sense, continue to make sense for the company. So in summary, I just want to say that, patents can be very powerful forms of intellectual property protection in that they protect a wide variety of different types of inventions, including designs and plants. They, patent inventions don't need to be commercialized, and that's what makes them so powerful, is they can just be secured. Those rights can be secured, and if competitors or industry moves in the direction of a patented invention and adopts it unwittingly, there could be a violation even without knowing that the infringement, that the activity, that the product, that the competitor or industry incumbent creates is infringing of a patent. So this could be, patents can be enforced against what are called innocent infringers, those who aren't even aware of the patent. And it provides strong legal remedies for infringers. Patent owners can obtain up to 3 times the amount of damages that they suffer if the infringement is determined to be willful. And sometimes a court may order what's called an injunction, which is an order to stop the infringement from occurring. That could essentially put a competitor out of business if they have to stop their production line of a product offering. But like all things, there's always a flip side, and with patents, it does have its pitfalls. Patents are expensive to obtain and maintain, and it could take a while to obtain a patent. Like that patent I showed earlier of the telescoping wand with the channel changer at the end for the TV. Well, maybe that would have been relevant for a couple years, but pretty quickly TVs evolved where they didn't have a dial in the front, and that invention was no longer relevant. So, and this is something that you see also in certain industries, for example, the apparel industry, because fashion changes so quickly, very few innovations in the apparel industry are patented, because by the time the patent would be issued, industry has moved beyond what that item has. Could be, I don't know, something related to padded shoulders, shoulder pads. Patent value is a function of enforcement. And as I described earlier, patent enforcement is expensive. Bringing patent litigation is an expensive process. But as a startup, you can say, well, does that mean I shouldn't patent anything because I don't have the money to enforce it? No. What you're doing with a patent is you're making a bet on the future. And you're saying, I think competitors, I think industry incumbents are going to go in this direction, and maybe 5 years from now or 7 years from now, this is where they're going to end up. You're making a bet on the future. And if you can predict the future with filing and obtaining a patent for an invention that you have, that could be very valuable. One patent usually isn't enough. The patent wars are fought with portfolios. So whatever cost that you have, you're going to multiply for filing and prosecuting a patent application. You'll multiply that many times over with the number of patents that you want to build your portfolio from or with. And then finally, patents provide the right to exclude, not practice the invention that you made. So you're going to want to you can't just sit on your laurels and say, well, great, I have a patent, I can do whatever I want. No, you're also going to need to be vigilant and perhaps do some searching to make sure that you're not going to step on the toes of somebody that might have a dominant patent and prevent you from making, using, or selling your invention that is covered by their umbrella patent. Patent ownership does not guarantee freedom to operate. So with that, I'm going to end and take questions if there are any.
Thank you, Kevin. That was really thorough. I have some questions, but I also want to make sure that I let those in the chat in the group ask questions. If you guys have questions, you can turn on your camera, use the hand raise function. I know that David has a question, so he'll be up. So my first major question is, you know, a lot of startups come through the garage, and you know, the basic question is always, should I or shouldn't I, right? You know, I don't know if there's an easy way to determine this. I know that certain types of technologies are harder to patent than others. Is there kind of like a metric or certain types of technology that are better kept trade secrets than trying to file patent? Like, is there some way that startups can kind of use a criteria or a metric that will help them to feel better about their decision to either file or not file, because it is expensive?
Yeah. First of all, I would say, you know, there are a lot of junk patents out there. So, and what I mean by that is patents that have very little relevance to the marketplace, or are just minor refinements of existing technology that, you know, happen to sort of squeak through the process. So, you know, really, if as a startup, not as a mature company, but as a startup where you have limited funds, if you've invented something that is really, you know,
One of a kind.
Well, not just one of a kind, but really significant, a really significant innovation where you think that, you know, this is where the future is going. And, you know, this 5 years from now, this is going to be super relevant. I think that's something to consider. With that, I will say, and this is going to sound odd, most big ideas have already been taken. And what I mean by that is it's really hard to patent a big idea because a lot of them have already been patented. What you might be thinking about is patenting, because most people come to me and say, well, can I patent my invention? It's like, no, it's probably obvious based on these three other things that have already, you know, exist. But what you could be thinking about is there a strategically important invention that you've come up with that any competitor would have to implement in order to achieve the functionality of your big idea that you've created? And what I'm going to give you sort of a, you know, a metaphor for this, and that is, if I want to go from Westwood to the San Fernando Valley, I can go through the Sepulveda Pass, and that's a choke point. I don't need, you know, so as a patent owner, you don't need to own the entire Santa Monica mountain range and put up a fence and block people from getting over from Westwood to the San Fernando Valley. All you need to do really is put a toll booth at the Sepulveda Pass and Laurel Canyon and, you know, the various canyon passes, and you'll effectively stop people. So that's what I mean by that. If there's sort of a choke point that you have functionality and you've sort of solved a difficult problem that others would need to solve essentially the same way in order to implement what you've done, that may not be extremely exciting, but it could be hugely valuable. So that's number one. That's one thing to keep in mind. The other thing, as I mentioned earlier, is if you have something that when you make it available publicly, it's going to be visible to competitors and they're going to be able to knock it off, then you should think about patenting, because patents will prevent that. You'll be able to enforce that kind of activity. So if you have a new type of pen and you put it on sale in Staples and you have a patent for dispensing ink in a unique way, in an effective way, then a competitor that would buy this pen and do the same thing, if that dispensing mechanism or system is patented, they would be infringing. So that's an example of a trade secret before you make it available. That's great commercially, but once you put it on sale, the world can see it and knock it off. Is that helpful?
Yeah, I think I mean, it's hard though. I think ultimately the answer is that there is no clear and distinct criteria that at the end of the day, you have to really make a decision one way or the other. And then once you make that decision, fully invest in it, because there's probably, you know, like half-heartedly patenting something is probably just as useless as not patenting it. I mean, I don't know. I just wondered, like, because patents are tough, you know, like enforcing them is basically out of the scope of a startup because they can't really necessarily afford it, right? So then it's like, okay, making the patent for a future day, right?
But it gives them runway to build revenue to enforce at a later point, and
yeah, exactly.
It protects competitive advantage to get through that valley of death and into series 1, 2, 3.
That's right. Right. They're making a bet on the future. And when they're successful company and have the resources to enforce, they'll have the patent available to do so. But you have to be very selective in choosing what to patent. And, you know, entrepreneurs, I think, need to be circumspect of advisors who say, oh, you got to patent something.
That's the question I have, Kevin.
Mm-hmm.
I mean, RC is asking the really, really brilliant question, and there isn't a great answer is what we're hearing. But one of the questions I have is, first of all, I'm USC faculty. I'm part of Viterbi Startup Garage, and I'm also building a startup with 2 colleagues. And we are filing for a patent because we have grant money to do that, and it's for that kind of thing. But one of the questions I really have is, who should those advisors be? Because it sounds like we should be talking to a person like you in that context of having a strategy and a portfolio strategy, not the VCs who are looking at us to have our protected, say, competitive advantage per se. And then the second part of that question, which is that's fairly obvious, you should be talking to somebody like you, is how do we pay for you when we can't pay for you? So what are the models that you and your firm work through in terms of having great legal support early on when we are still in that valley of death moment? Right.
So, you know, in deference to Dave Eastman, who's on the call, I'm going to say that, you know, don't listen to VCs. Because because, you know, they don't know unless they are really sophisticated in the patent game. They're just, I think my experience is they're checking a box. And so my response on their list of diligence questions, and on my response to the question of that often comes from investors, which is, you know, do you have any patents or do you have any IP? And a startup could answer that by saying, yes, we have IP. We're IP aware. We have a plan for protecting. We have agreements with our employees and contractors. We have a plan for protecting our trade secrets. And in the future, when we get some money, we have a process for determining what patents make sense to file to implement our business plan. But right now, we don't have any, and that's okay. I don't think VCs expect startups from the get-go to have patent applications or patents on file, unless there is just something mind-blowing that, you know, could be patented, and, you know, which is unusual. And then the question is, why haven't you filed on that? And to your question earlier, David, which is, you know, so who should we be talking to come to this analysis? Yeah, it's an advisor who understands the intellectual property game, the intellectual property field. I find that a lot of patent lawyers are sort of kind of one speed. You know, it's not driven by, you know, financial interests. It's like the carpenter who sees everything as a nail. You know, file a patent application, build a portfolio. That's what you do. I was a patent lawyer in a firm like that. When I asked the senior partner what happens to all these patents that don't end up getting commercialized, his answer to me was, that's not our problem. We just get the patents. That's the wrong answer. The right answer is, what relevance does this have to the company's business plan?
But the second part of my question is, do you, for example,
pay for it?
Right. Do you take equity? Are there other models other than us having to write the hourly billable rate kind of fees in the beginning? And then I have a follow-on question.
So here's the answer to that, which is, you may not like this answer, but I think it's the right answer, which is we as a firm, we right size the services that we provide to the company's needs. We don't over lawyer. And so if a company is just a startup, we give you sort of what you need in order to, at that early stage, to be IP aware, to be thinking ahead of what you're going to need at the next phase, but not spending billable hours to do it. And yes, to your question of, do we have alternative fee arrangements? Do we take equity on occasion? Yes, yes, and yes. But really, that's just kicking the can down the road. Really, what we want to do is you want to be in control of what your IP spend is every step of the way, whether you're paying for it now or whether you're paying for it later. And it needs to. So here's an example, or here's an explanation. In my mind, it doesn't really make sense to invest a lot of money and scarce capital in protecting IP at a point in time when the company is still refining or determining whether its technology works or is commercially viable. You want to test, you want to validate your business hypothesis and get that together, and then say, okay, now we've got something. Now let's put the pedal to the metal and really, scale this up. And that would include investing in intellectual property protection.
And right sizing our spend. Last question, different topic. Very early on in the deck, you talked about sort of the 3 key things for patentability. You also said that algorithms are not patentable, and you made a comment about SaaS businesses having troubles developing patents. We're a SaaS business, so that really piqued my interest. We're not patenting SaaS, we're patenting something in the system itself. But maybe you could elaborate a little bit why an algorithm, for example, isn't patentable. And I think of Google, and did they just go with trade secret versus patent in the original case? And why SaaS is so difficult to patent around.
Right. Well, algorithms, like a mathematical equation, is not patentable. Yeah. Well, no. It's just not patentable subject matter because it's an abstract scientific or technological principle or function without doing something. If an algorithm that does something is patentable, and it's patentable as a process. So what you're doing is you're using an algorithm to figure something out or to do something.
Super clear.
That is patentable.
Evan?
SaaS,
Oh, sorry.
just really quickly, and the problem with SaaS, and I'm not saying SaaS isn't patentable, I'm just saying that certain SaaS platforms have difficulty getting patents because they're implementing processes that take place in the physical world online, and that could be deemed obvious.
Meaning it's not novel, it's already happened, like whatever.
Could be novel, but it's not non-obvious.
There you go.
Novelty
Okay.
and obviousness are 2 different things.
Thank you. Kevin, thank you so much.
You're welcome.
Hey, Kevin, I probably should have asked this earlier because it's the ultimate can of worms, but I noticed that your chart about the win percentage of litigants versus defendants, was 2010 era. And can you talk about how the world has changed since AIA passed in 2013 about the PTAB death squads, where something like, I think the last I heard was 90% of patents are blown out by these non-judicial entities, even though they're not Article 3 courts, and how essentially kind of the Googles and the Apples, et cetera, of the world. Again, I'm still involved with a company that I wish I'd never invested in, that even though we've won against Apple 4 times in court, we are still waiting to be paid 11 and a half years after filing suit. So, what's the point these days of even filing patents? Because if somebody wants it, they're going to infringe, and they will just bankrupt you and take you on for a decade and run you into the ground if they want your technology.
Good point, Dave. I mean, I don't have really much to add to that because you really hit it on the head. All those things have occurred, and to the disadvantage of patent owners and as a disincentive to seeking patent protection. It hasn't, those recent or more recent events haven't gutted patent law, but they've certainly made it less powerful, and they've made patents less valuable. And in fact, a friend of mine who's in the business of buying and selling patents has told me that the price, if you can take an average price of what you can sell a patent for on the market, has dropped precipitously in recent years, to the point where if you are getting a patent to maybe sell it someday in the future, you'd be lucky if you break even on your costs. So because the market has responded, the market of buyers has responded for the very reasons that you just identified, that patents are very difficult to enforce because they do get invalidated. You will get buried by litigants who have the money to pay you in litigation. And if you're suing somebody that isn't going to bury you, they may not be able to pay you if you do win. So that's a quandary, certainly.
Yeah, since you commented.
But let me just add.
Okay, sorry.
But let me just finish by saying, but does that mean you shouldn't file for patent applications today? No, I think because these are recent trends, and it is possible that the law will change, industry or practices will change, and so again, you're making a bet on the future, and the future is long. So if I wouldn't run out and file a bunch of patent applications, but these factors are important to keep in mind. And it is possible 10 years from now, we may be having a different conversation about the viability of patent enforcement and the value of patents themselves.
One certainly hopes, just for the future of innovation in America. I will say this to defend BC's, is that if I'm ever asked, is that my response is usually think long and hard, and whatever you can, keep as a trade secret, because it saves you the expense. And unlike a patent where you're simply laying out to the efficient infringers how to either do a workaround or how to steal your technology, you can keep it private. So
right.
But Dave, when you're evaluating and you're doing diligence, especially in early stage, how much does having trademark, having patent increase the potential valuation, or is it, or does it not affect the way you're running your numbers?
Much less than it used to, for the reasons that we just went through. I think what it really comes down to, it has moved way down the list behind, what's your business model, what's your execution ability, and again, are you in a position where is defending your patent going to make you unassailable? That's absolutely not the case anymore. So what will make you unassailable, or what will move you to the front of the line in terms of generating revenue? It's absolutely not going through the multi-year and relatively expensive process of getting a patent and then just kind of saying, ha ha, we've got this. It's like, by that time you're dead. I mean, I think most VC who agree with that, it's what's your business model? What's your management team? Do you have a sense of the market you're going after? How quickly can you execute on it? And given how cheap, computing power, AWS, hardware, et cetera, is these days, speed is of the essence, much more important than I think capital used to be.
Thank you, Dave.
I have a follow-up. I have a quick follow-up to Dave mentioning, the fluctuation, and then you mentioning how prices and the value of patents have responded to that. And I'm wondering if the cost of patents have also responded. Do those fluctuate as the price of patents fluctuate, or is just the cost standard and it's, you either do it or you don't? Do the costs ever go down when the price and value of patents go down?
I think the only way they fluctuate is by going up.
Yeah, lawyers don't reduce their hourly fees. It's more a function of fewer lawyers coming out of school are going to focus on concentrating, their efforts in the patent world.
Yeah, that's probably true.
Well, we are well over time, and I have a hard stop at 2, but I did want to just get any parting advice from you, Kevin, in terms of the pros and cons, especially if you have some students on the line who are just thinking about becoming entrepreneurs. And obviously patenting is one of the aspects of protecting your IP. So just any general advice you can give to a newcomer?
Yeah, I guess, in this whole discussion of patents, we've been focusing on inventions and the protection of inventions. And I would encourage entrepreneurs and aspiring entrepreneurs to think about something a little bit broader than inventions, and that is innovation. So what problems are you trying to solve, and how are you innovating? What creativity are you going to apply to come up with solutions to those problems? And then the afterthought, the sort of secondary consideration is, do you have an invention? What's the intellectual property? And really, how do you keep from losing it? But I really, encourage folks to think of, like I said on my last slide, go build something, come up with a solution, innovate, be creative, experiment, take risks. That's, because at this stage, and it is a really precious time when you're just starting out, the stakes are so low. So you can take a lot of risks and come up with something that hopefully, perhaps, will lead to something really monumental down the road.
Thank you, Kevin.
I just wanted to also say thank you before we run out of time.
Yeah.
You're very welcome.
I really do look forward to having you back in 2 months' time.
2 months.
Yep. And really quickly, as I do for all of these, I want to plug our next week's speaker. Oh, did I not save her? There she is. Next week, Victoria Hodgkins. She will be with us. And I won't be on, but David Gerber is going to moderate next week's. And so it'll be a really fun one. I will watch the video once I get a chance. So please RSVP for this. Thank you once again, Kevin. You really are such a great resource to the garage.
My pleasure.
Thanks very much.
Thanks,
Kevin.
everyone.
Bye, everyone.
Take care.